on this morning's Ag Issues program. A pleasure, as always, to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Doing well, thanks.
Well, you have a couple of big topics for discussion that you have on your blog, and one we're going to get to first off, and I think several people, many farmers and ranchers may have a stake in this, agritourism, because that has definitely expanded in recent years, used a lot in most cases as an additional incoming stream for some farming and ranching operations as well. But engaging in agritourism activities on the premises also means that the public would be invited to in that aspect as well, and that raises, of course, the potential for injury, and then further down the road for potential liability too.
Yeah, it's that liability issue, Greg, that is the big concern for landowners. I've seen some surveys that are out there that indicate about 80% of the survey respondents have listed liability concerns as a major limiting factor preventing them from engaging in agritourism activities on their farm or their ranch or just their rural property in general. And along with that, also cost and availability of insurance. And so that's really, or those are really the issues that have driven state legislation over the years to try to provide some protection from the liability standpoint, which would in turn also reduce the cost of insurance.
And that is one as well that, and I'm sure there have been some cases in the books concerning our judgments that have taken place concerning liability or incidents that have happened for specific agritourism situations.
Well, there are, and fortunately, the agritourism statutes have really worked to lessen the liability risk that a farmer, a rancher, or a rural landowner would have when they have people come onto their property for, all types of agritourism activities, hunting, fishing, tours, hay rides, those types of things, even roadside stands and you-pick fruit and vegetable operations, too. So they have reduced the liability risk because basically what the statutes do is they take the landowner's or operator's standard of care down to one where you're not liable for any injuries to someone that have those injuries sustained while participating in an agritourism activity, only unless you are acting in what the statutes say is a willful or wanton manner. And so just the standard of reasonable care, that has been lessened to, you don't have to warn of hidden dangers. You don't have to treat them like an invitee under the law. As long as you're not out there willfully or wantonly injuring people, then they come basically on the property at your own risk. Now, state statutes may require the posting of signage, and the statutes from state to state are all different, and so you have to be familiar with what each particular state's rules are, and even some states, even though it sounds weird, there are a couple of states out there that say, well, you don't get the protection of the statute if you charge a fee. Well, my response to that is, well, why do we have the statute in the first place if we're trying to encourage people to come on the property and we're trying to provide an additional income stream for farmers and ranchers and rural landowners? Well, you certainly would want the statutory protection to apply in the situation where a fee is charged. But there are a couple of states out there where if a fee is charged, you lose the protection of the statute. That just seems ridiculous to me. But we just have to be familiar with each state's rules.
All right, another topic we want to discuss, and people know this as ag-gag laws, or it's more, I guess, the common reference, and that, of course, is attempts to shut down animal confinement operations by activist groups. We have seen many state legislatures, enact laws designed to protect those businesses by limiting access. And I know there have been some movement in the courts that have been laws that have been challenged, and specifically looking at that in the state of Iowa.
Yeah, Iowa and the Kansas statute actually is the request is in. The petition for certiorari has been filed with the United States Supreme Court with respect to the Kansas statute on a case coming from the 10th Circuit Court of Appeals. So that's sitting out there too. But just last week, the Federal District Court for the Southern District of Iowa ruled that the second attempt by the Iowa legislature, their revised version of their statute, was unconstitutional for a violation of free speech. And that's a difficult one for basically on common sense grounds for a lot of people to understand is why is lying with the express purpose of causing harm or sabotaging a business protected speech? Well, as I point out in my article, there's a whole line of Supreme Court cases that says it's not until we got to 2012 and the majority of the court on the Stolen Valor Act kind of changed the rules with respect to that, although there was a very strong dissent by 3 judges in that case. But why is lying to gain access or to gain employment and get access to an ag confinement livestock production facility deemed to be constitutional? And so that's the problem that legislatures have tried to address in some of the livestock, where the livestock industry is prevalent in those states. Those legislatures have tried to address this issue. And if I remember right, Kansas was the very first state that passed any type of law trying to deal with this. And what they're addressing, of course, are these groups that are vehemently opposed to animal agriculture, and particularly confinement animal agriculture, and they want to gain access to get inside the facility so they can tape videos and take pictures and then use those in the media to kind of inflame the situation, to show people what goes on inside a facility and claim that there's mistreatment and harm to animals. And certainly, and I want to get to this before we're done, what are some common sense steps that employers can take? And one of those, obviously, is don't mistreat your animals. But how do you protect the business from those that deliberately want to sabotage your business? Is there a constitutional way to do that? And that's the main issue that when we get into these various statutes that the legislatures are trying to address. And before we finish today, I want to talk about what's happened in Indiana, because I think Indiana may have the correct approach on this.
Yeah, and quickly before we get to the break, what was the difference on Iowa, because this is their second attempt, or when they modified the law, what was the difference from when they originally passed it to the second time that they passed it that obviously has not held water with the courts?
Well, the court said you changed a few words, but you really didn't change anything. Basically, the Iowa statute has 2 provisions in it. The initial version criminalized ag production facility fraud if a person willfully obtained access to the facility by false pretenses. That's the access provision. The other provision is the employment provision, and that's where a person would make a false statement or representation as part of an application or agreement to be employed at the facility. And the law also said that the person had to know that the statement was false at the time it was made, and that it was made with an intent to commit a knowingly unauthorized act. So there was no unknowing part of this statute. This seemed to be the right way to do this. You know that you're lying. You know what your intent is. You misrepresented that to get access to harm the business. Now, the initial statutory version, of course, was challenged in court, and the employment provision was deemed unconstitutional. But the access provision of the Iowa initial version was upheld as constitutional. Then the legislature, in reaction to that court case, saw that and said, okay, we need to fix the employment provision here, because that's what the court struck down initially. And so they went back in and retooled the statute. And just last week, the court said, you didn't change it very much. Still means the same thing, and so it's still unconstitutional. Iowa has that issue going on. I don't know. We haven't seen yet whether they're going to appeal the trial court judge's opinion to the Eighth Circuit, but you got that Eighth Circuit opinion sitting there on the first version of the statute. I'm not sure that the Eighth Circuit would rule differently on the second version of the statute, but that is a bit contrary to, since part of the Iowa statute was upheld, we do have some discrepancy between the circuit courts.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law joins us. And one of the things we have been discussing concerning the ag-gag laws, one that has been ruled against in the state of Iowa. Kansas has had the same issue as well. And Roger, before the break, you had mentioned states that have had issues, but you also mentioned the state of Indiana and their approach to this law, or they call it the Indiana trespass law.
Yeah, this is an entirely different approach, and what it does is remove the constitutional baggage associated with the what's known and what you referred to as ag-gag laws. I hate referring to them that way, but nevertheless, that's how they're known. It takes all that constitutional baggage out of it, and basically what they have done, back in 2014, the Indiana legislature passed, governor signed into law, the Indiana trespass law, and under that statute, trespass is defined as being on a property after being denied entry by the property owner. In other words, you're told you can't come on here, or in some other manner it's indicated you don't have the right to be there, or a court has ordered you to stay away, or there's a posted sign, and they do have a purple paint law in Indiana too, like Kansas does, so indicating you don't have a right to be here, and so you've been told you can't be there, but you nevertheless come on the property. So if the trespass involves a dwelling in that situation, and they've also defined ag operations, so confinement ag operations, to be a dwelling, then in that instance, the landowner doesn't have to deny entry for a trespass to be established. Just the fact that you're there is a violation of the statute itself. And then the law sets up various thresholds for criminal violations. Now, what that is doing is it's basing property entry on the legal property interest of that of a license. So you have a license to be there in certain situations, but if you exceed the scope of that license, then you are deemed to be a trespasser. And so a license is just simply a permissive land use, which if you don't have that permission, you're deemed to be a trespasser. So if I'm a hunter and I'm hunting somebody's premises with permission, I'm known as a licensee. I have a license to hunt for the limited purpose of hunting only. And then if I were to videotape any activity on the premises, that would be a trespass because it exceeds the scope of my license. That's an unlawful entry. So that's the idea they've taken. Okay, you've got the right to be here as an employee. You've got the right to be here, say, as a milk truck driver. But once you exceed the scope of the business purpose for which you were there or the express purpose of the license that was granted to you, then you're a trespasser. So as soon as you pull out that video camera, as soon as you pull out that phone, you can be terminated from the job. You've exceeded the scope of your license, and now you're a trespasser. So the same result in these situations, as I've indicated, would be for a farm employee. So video recording would be outside the scope of employment. And so what this does is that statute focuses on the property interest of a license and that of a trespass for unlawful entry. And so that claim of a possible free speech violation, I think, is eliminated under that approach.
Now, you also mentioned looking at common sense things that those facilities can look at or should take a look at with regards to, simple things of, hey, if this is the case, you need to do this, or if this is the case, you need to do this, right. Or if this is the case, you shouldn't do this, as far as some of the common sense things to think about.
Yeah, I get this question rather frequently, Greg, and what I tell these facility owners is, look, where you need to start with, while the courts get this sorted out, and while the legislatures figure out how they're going to deal with this, let's put some common sense steps in place. And the first one, of course, is don't mistreat your animals. That should always be the standard. And then proper hiring practices are also very important. So what I think you need here, and we don't often like to do this in agriculture, and we don't formalize agreements to the extent we should, but I think in this instance you need a well-drafted employment agreement that you're going to use when you hire workers in and for an ag animal facility, and that'll help you screen potential hires. And that agreement should specify in detail the job requirements and what is not permitted to occur on the premises and inside buildings, and specifically say, you cannot have a phone in there, you cannot have any type of video recording device, and be very specific about that, and give the employer the right to search every employee for devices that could be used to record activities on the farm and in the farm buildings. And if somebody doesn't like that, then they can go get a job somewhere else. Also, employee training should be provided and documented, and I think it's pretty critical that employee conduct be closely monitored by the manager of the farm or managers to ensure that the employees are acting within the scope of their employment and that animals are being treated appropriately. So it comes back to the farm, the way it's being operated, make sure that with respect to animals, it's being operated exactly the way it needs to be, that the animals are not being mistreated. And then with respect to employees, make sure they're acting within the scope of their employment, but be specific in that employment agreement. And so those are, we can, I think, minimize the risk to the facility by improving hiring practices while the law is trying to sort through all of these various types of statutory language that the various states have.
That was just going to be my next point, that various states, different languages, this isn't going to go away, in other words.
No, there are groups out there that are dedicated to damage or eliminate certain aspects of animal agriculture, and they'll use lies and deception to become employed or otherwise gain access. It's unfortunate that they exist, but they're not going to go away, so the issue's not going to go away. So it's something we have to be very serious about if we have confined animals. One, that we're operating properly, that we're, again, not mistreating those animals, and two, that we're closely screening and monitoring employee conduct to try to minimize the risk while all of this gets sorted out in the legal system.
And as we wrap this up, Roger, if people want to learn more or read more about your thoughts on this, they can go to your blog to get the full read on that?
Yeah, and that blog's easily accessible through my website, which is washburnlaw.edu, and then /WALTR, Washburn Agricultural Law and Tax Report. That opens up, and on the home page down the left-hand side, they'll see the Law Professor Blog Network and my Agricultural Law and Taxation blog. Click on that. There's also a way there to get an email update of when I add something to the blog, so you wouldn't have to go to the website directly every time. You could just get the email notification.
All right, sounds good. Roger, as always, a pleasure. We appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.